Welcome to Module 5 about data protection policies in the training program for NEETs in the frame of the Learning2gether project, which is a project co-funded by the Erasmus Plus program of the European Union. First of all, as an introduction, we are going to review some key concepts about the new GDPR. So first of all is, what is a personal data? So in this module, we will cover the area related to data protection policies and the new General Data Protection Regulation, also known as GDPR, which is one of the most trending and important issues in the European organizations and business since last May 2018. This is, without doubt, a technical skills that current European employees need to be proficiency at. And what constitutes a data processing? So, processing is understood by the European Commission as what covers a wide range of operations performed on personal data, including both manually and automatically. That means that any collection, recording, organization, structuring, storage, adaptation or alteration, retrieval, consultation, use, disclosure by transmission, dissemination, or otherwise making available, alignment or combination, restriction, erasure, or destruction of personal data applies to the processing of personal data wholly or partially by automated as well as not automated processing. In this slide, we can see some examples about a personal data. So for example, a name, a surname, let's say John Smith, that would be a personal data. A home address, an email address such as john.smith@company.com, for example. An identification card number would be another kind of personal data. A location data, for example, the location of data function on a mobile phone, or an IP address. Some examples of data processing would be, for example, staff management and payroll administration in companies, access to consultation of contacts database containing personal data of our customers, sending promotional emails, or posting a picture of a person in a website. Another key concept to understand the GDPR is what is a data protection policy. So this is an internal document that serves as the core of an organization's GDPR compliance practices. It explains the GDPR requirements to employees and states the organization's commitment to compliance. The data protection policy needs to outline how the GDPR relates to the organization. So it doesn't mean to provide specific details on how the organization will meet the regulation requirements, as these will be covered in the organization procedures. Data protection policies have three main aims. The first one is providing the groundwork from which an organization can achieve the GDPR compliance. Second is making the GDPR understandable for staff members. And finally, the third one is proving that organizations are committed to GDPR compliance. Article 24 of GDPR states that organizations have to create a policy in order to demonstrate that data processing is performed in accordance with this regulation. So the minimum information that policies should cover are the following items. So the first one would be the purpose of the policy, which means is an introduction explaining the importance of the compliance of the policy and why this is necessary in relation to GDPR. Then would be definition of key terms. The GDPR is full of data protection terminology that needs to be explained. The policy should include a relation of suitable terms to be clarified. Third one would be the scope. The GDPR requirements apply to European Union residents' personal data and anyone in your organization who processes that information. Then would be the principle. What is under GDPR? So, according to Article 5 of the GDPR, there are 7 key principles which lie at the heart of the general data protection regime. And the failure to comply with the principles may leave you open to substantial fines. We also have the data subject rights. The GDPR endows individuals with 8 data subject rights that we will see further in this module, and it is important to define them and ensure that they are met. And finally, the Data Protection Officer, DPO. As it has been mentioned before, the GDPR endows individuals with 8 data subject rights. So we are going to define them really briefly just to ensure that they are understood and they will be met. So the first one is the right to be informed. So you have right to information about the processing of your personal data. The second one is right of access, which means that you have a right to obtain access to the personal data held about you. The third one is right to rectification. You have right to ask for incorrect, inaccurate, or incomplete personal data to be corrected. Right to erasure. You have right to request that personal data be erased when it's no longer needed or if processing it is unlawful. The fifth one is the right to restrict processing. You have right to request that decisions based on automated processing concerning you or significantly affecting you can be restricted. The sixth one is the right to data portability. You have right to receive your personal data in a machine-readable format and send it to another controller, which is called data portability. 7 is the right to object. You have right to object to the processing of your personal data for marketing purposes or on grounds relating to your particular situation. And finally, rights related to automated decisions making, including profiling. The GDPR has provision on automated individual decision making and profiling. Profiling can be part of an automated decision making process. And now let's talk a little bit about the history of GDPR and its legal framework, which means like how did we arrive until May 2018. So before the GDPR came up, the Organization for the Economic Cooperation and Development published its guideline on the protection of privacy and transborder flows of personal data. It was a set of recommendations originally adopted on 23 September in 1980 and endorsed by both the European Union and the US that set out to protect the personal data and the fundamental human right of privacy. These guidelines were the basis of many national laws regarding data privacy. However, they were not binding and the levels of data protection varied greatly even amongst the different EU member states. After this, the Data Protection Directive 1946 EC of October the 24th in 1995 was the European Union's answer to the division of privacy regulations across the EU. This directive stayed true to the original recommendation of the OECD and the core concept of privacy as a fundamental human right. Although this directive was meant to bring together the laws of different member states, it was still a directive which left some room for interpretation during the transposition into individual national law. This fact, along with today's rapidly changing data landscape, has led to the necessity for another update to the regulation environment in the EU. This way, the GDPR was designed to fit today's technology while remaining general to protect the fundamental rights of individuals through future waves of innovation. Following a 2-year post-adoption grace period, the GDPR was fully enforced through the European Union in May 2018. And in this table, we can find a short timeline of how the regulation reached the point that is today. So as we can see here, everything started in October 1995 with a previous legislation in which the Data Protection Directive, the 9546 EC, was created to regulate the processing of personal data. Later, between January 2012 and June 2015, they will set several legislative proposals. So the first one is, and the European Commission initiated a proposal in order to update the data protection regulation of 1995. Later, in 2014, the European Parliament approved its own version of the regulation. And later, in June 2015, the Council of the European Union approved its version in its first reading, allowing the regulation to pass into the final stage of the legislation, also known as the trialogue. The trialogue started in June 2015 until December that year. And after several meetings to cover an agreement of the overall roadmap for the trilogue negotiations, the Parliament and the Council became to an agreement. And finally, in April 2018 and May 2018, we have the approval and adoption of the GDPR that regulates the Council of the EU and the European Parliament. So now let's go to some further concepts about the GDPR. For example, what are data protection authorities, also known as DPA. So the data protection authorities are, according to the European Commission website, independent public authorities that supervise, through investigate and corrective powers, the application of the data protection law. These authorities provide expert advice on data protection issues and handle complaints lodged against violation of the General Data Protection Regulation and the relevant national laws. There is one DPA in each EU member state. The data protection authorities in the EU member state where your company or your organization is based will be usually the main contact point for your questions on data protection. Another important question is, what are the main aspects of the General Data Protection Regulation, the GDPR, that a public administration should be aware of? Public administrations are subject to the rules of the GDPR when processing personal data relating to individuals. National administrations are responsible to support regional and local ones while preparing for the application of the GDPR. When processing personal data, a public administration must respect some key principles such as fair and lawful processing, purpose limitation or data minimization or retention. Prior to processing, individuals must be informed about it. That's very important. And not only the designation of the data protection officer is required in public administrations, but also it must be ensured that appropriate technical and organizational measures have been implemented to secure personal data. In cases where personal data held is disclosed accidentally or unlawfully to unauthorized recipients or is temporarily unavailable or altered, the breach must be notified to the Data Protection Authority without undue delay and at the latest within 72 hours after having become aware of the breach. The public administration may also need to inform individuals about this breach. And now we are gonna make a brief analysis about the GDPR. So in this slide, we provide a summary of the regulation, which is divided in 11 chapters, as you can see here, and 99 articles. So we are going to review just a little bit every title for each chapter. So the first chapter is General Provision. This chapter discusses the aim of the regulation, the scope of the regulation, that means where it applies and where it doesn't apply, and essential definitions. Second chapter is about principles. In this chapter, it outlined the roles of processing and protecting personal data. In chapter 3, about rights of the data subject, it is discussed the rights of the data subject, including the right to be forgotten, the right to rectification, and the right to restriction of processing. In chapter number 4, Controller and Processor, this chapter covers the general obligations and necessary security measures of data controllers and processors, as well as data protection impact assessment, the role of the data protection officers, codes of conduct, and certifications. Chapter number 5, Transfer of personal data to third countries or international organizations. This chapter provides the rules for transferring personal data that is undergoing or will undergo processing outside of the Union. Chapter number 6, Independent Supervisory Authorities. This chapter requires that each member state have a competent supervisory authority with certain tasks and powers. Chapter 7, Cooperation and Consistency. This chapter outlines how supervisory authorities will cooperate with each other and ways they can remain consistent when applying this regulation and define the European Data Protection Board and its purpose. Chapter 8, Remedies, Liabilities, and Penalties. Chapter 8 covers the rights of data subject to digital remedies and the penalties for controllers and processors. Chapter 9, Provisions relating to specific processing situation, covers some exceptions to the regulation and enables member states to create their own specific rules. Chapter 10, Delegated Acts and Implementing Acts. This chapter covers articles regarding the exercise of the delegation and the committee procedure. And finally, the chapter number 11, Final Provisions, explains the relationship with this regulation to pass directives and agreements on the same subject matter, requires the Commission to submit a report every 4 years, and enables the Commission to submit legislative proposals. Well, and once that we have all the theory about the GDPR, and we have gotten to know briefly what GDPR is and data protection policies are, it is also important to know how GDPR affects to our marketing campaigns. There are only 3 key areas that marketers need to be worried about, and we will try to explain those concepts about those 3 areas. So the first is data permission. You cannot assume that a customer's permission, but users need to physically confirm that they want to be contacted. That's very important in marketing related to GDPR. The second key concept would be data access. That means that the user can choose when he wants to be forgotten of your database. Users have the right to have control on their data, how their data are collected and used. Marketing professionals have to make sure that users can easily access to their data and remove consent of its use. And finally, the data focus. Marketers need to really focus on crucial information and not having more data from someone than actually needed. It is important trying to avoid collecting any unnecessary data and stick with the basic. So here we can find a great checklist including 9 practical tips aiming to help the compliances of the new GDPR related to marketing actions. So the first one would be audit your mailing list. It's important to be audited and updated. Second is to review the way you are collecting your personal data and make sure that it is in compliance with the GDPR. Also, invest in a content marketing strategy and launch a pop-up on your website. Also, you need to educate your sales team about the new sales techniques and how those techniques are in compliance with the GDPR. Another very important tip would be start centralizing your personal data collection into a CRM system. Also, understand the data you are collecting in more detail. Trying using push notifications. And finally, update your privacy statement. It needs to be taken into consideration that GDPR aims to increase data quality in order to delve deeper into the needs of their prospects and customers. Its compliance is very simple. Just don't contact anyone unless they specifically ask you to be contacted. That would be like the main aim on how to well use the GDPR for your marketing actions. So I hope you find this webinar interesting and useful for um, your marketing actions, and that has helped you to understand a little bit better about the GDPR, which is a hard subject. Bye.